The board has had a bit of a discussion before the case, and we thought that at this stage we don't need to trouble you on section 12, but we would welcome your brief submissions on the construction of the policy.
Very well, my lady. Thank you. My lady, my lords, good morning. My name is Brian Maury, and I appear together with Mrs. Janelle Sands on behalf of the appellant, and my lady friends, Mr. Cedric Parker and Mr. Khalil Parker appear for the respondents. My lords, this is an appeal from the judgment of the Court of Appeal of the Bahamas, dated the 30th of May, 2013. Your lordships will find that in the record at page 332.
You can assume that we have read the written submissions that both parties have put forward, that we have read the judgments in the courts below, and we have probably read the insurance policy as well.
I'm very much obliged, my lady. That will, I think, substantially abbreviate.
That's all we need to know, isn't it?
Yes. I think my task then is much more simple.
I'm trying to make it simple.
And narrow. I'm obliged, my lady. With regard to the construction point, moving straight to the point that your ladyship has asked me to address, our submission is that the Court of Appeal erred in its construction of Section 2 of the policy in holding that the policy was on risk at the time of the accident when the vehicle was being driven by Mr. Edgecombe, who was an employee of the company which, with your permission, I will refer to as CCT. And we submit that the fundamental error which the Court of Appeal made was that it did not construe Section 2 in the light of Section 3, which contained the general exceptions to the policy. I know that you have looked at the policy, but if your lordships would just indulge me for a moment and look at the policy starting at page, I won't take you through it in detail because I've taken your gentle nudge that you've looked at it, but just to highlight one or 2 points starting at page 100 and I beg your pardon, page 98 of the record. Well, that's the first thing I'd just like to draw to your attention on page 98 is the heading General Exceptions, which you will see in the left-hand column. Mm-hmm. It says under that column, or under that heading, the exclusions that apply to the entire contract. Now, of course, the respondents are submitting that the exclusion in Section 3 only applies to one limb of Section 2, and it does not apply to the policyholder itself. Our submission is...
Does that mean that on their case, anyone who is driving on behalf of the policyholder needn't have a driving license, for example?
Well, my lord, with respect, I think that is what it would mean. And in our respectful submission, that is one reason why we say with respect, it cannot be the right position. But that I think would indeed be the logical conclusion. And if your lordships just look at, if we can move over quickly to page 104, this is the Section 2. And it would appear that the Court of Appeal construed this section almost without Section 3, and then looked at Section 3 almost retrospectively, as opposed to looking at Section 2 as being read subject to Section 3. Now, if we look at Section 2 at page 104, clearly the policy does cover two different categories of persons. The first one is the policyholder. And your lordships will see that if I can just briefly read that short paragraph, we will insure you for all sums which you may have to pay for death of or injury to other people or damage to their property as a result of any accident involving any vehicle which your certificate of insurance allows you to drive or use. Now, there, of course, we emphasize that you have to look to the certificate in order to see who is allowed to drive or use the vehicle. And then we have the second category under the rubric Other People, and it says we will also insure anyone you allow to drive or use your vehicle as long as your certificate of insurance allows this. Again, pointing to the certificate as the critical document. Now, my lads, forgive me, if I can take you back for 1 minute to page 98, I would just like to refer you to what it says about the certificate. This is in the right-hand column under number 2. The heading is very important. And your lordships will see under 2, it says, the certificate of insurance is the most important component of this policy. And then if we go down to about 5 lines from the bottom of that short paragraph, it says you also have to return it, that is the certificate, to us, if you want to make any change to your policy, such as adding a new driver, changing your vehicle, or cancelling your policy.
There's also a bit in the bottom of the left-hand column, isn't there?
I'm obliged, my lord. I'm obliged. That is actually under the heading Certificate of Insurance. It says proof for the authorities that you have the minimum insurance required by law. It also shows the persons who are covered to drive under your policy. Now, my lords, if I can just take you to the certificate, I know you're familiar with it. It's at page 91. And this is in a prescribed form. Your lordships will see in the bundle of authorities under tab 2. This is in a form which is prescribed by the regulations. It's at page 529 of the bundle of authorities. And this certificate is actually covered by regulation by Rule 3B, which is in what's known as Form B. And that is at page 530 of the bundle. Going back to the certificate, your lordships will see items 5 and 6 are what we would wish to draw to your attention particularly. We know the vehicle, it's a Toyota bus. We know the policy holder, it's Convenience City. And then 5 reads, persons or classes of persons entitled to drive. Now, my lords, our submission is that in construing the policy, in order to find out who is authorized to drive under this policy, thereby putting the policy on risk, you would have to look at item 5, which would be the definitive statement of who is authorized to drive under this named drivers clause in the policy. And your lordships will see there are 11 named persons. And then, of course, you have item 6, which deals with the limitation of use. And there's no real dispute over this in the sense that at the time of the accident, the vehicle was being used within the scope of item 6. It is being used for the carriage of passengers or goods in connection with the policyholder's business. So,
can I just ask one question? I noticed that your written case refers to the people in paragraph 5 as your clients, sorry, not your clients, as Convenience City Transit's employees. Is there actually positive evidence to that effect?
my lord, I looked for that actually, and I don't know if it's disputed by my learned friend. I couldn't find it in the record. I think we know of that because of other documents which may not be before the board.
Yes. I mean, one has to say that as a matter of perhaps common sense, it seems unlikely that Convenience City Transit running some sort of city bus service is ensuring all the neighbours on the block.
Yes,
I also looked for whether there was any evidence about whether these 11 named people were employed to drive, and I couldn't find that, as you have not, Mr. Marie, but I also was inquisitive as to whether there was any evidence as to whether these, if they were employees, were the only employees, or whether there were quite a few more. Because I think we're talking, this certificate only deals with one bus, but I think somewhere we see that there were 6 buses.
yes, my lord, absolutely. Well, I regret that I don't think there's any evidence on either of those 2 points before the board. As I said, I don't know whether or not it's common ground, but I can't give evidence, of course, at the bar.
No, quite.
But what you have got told us is and pointed out is that this certificate follows strictly the statutory or regulatory form,
Yes, my lord.
and there's really no other way it could be filled out.
And indeed, my lord. And in terms of the actual point that the respondent is running, as I understand it, and which the Court of Appeal decided, and this is, I understand, a hypothetical that I will put to test the position. If this company, ex hypothesi, employed 300 people, then on the construction which the Court of Appeal gave to this policy, all 300 of those persons would be authorized to drive these vans, simply by virtue of them being employees. They could be secretaries, they could be housekeepers, they could be executives, and of course, that would very substantially affect the rating of the premium. Because what we have here, and I don't think this is disputed, and indeed, I'm reluctant to speak to this panel about some of these cases because your lordships actually wrote the judgments. So it's a bit daunting to address it. But your lordship, my lord Mance will recall, he addressed this point in the presidential case about the rating of the premium. And one of the reasons why an insured elects to have a named driver's clause.
We all know this from our personal experience.
Indeed, my lord.
I mean,
But if you have children, you know this.
every time.
Particularly if they're under 25. Yes, I understand. If they happen to have a sports car. If they like fast cars and they're under 25, then I think we all know what that means. So, in fact, this policy would have been underwritten on the basis of the 11 named drivers. And of course, it did come as quite a shock, not only to the insurance company, but to the industry, when the Court of Appeal decided that this named driver's clause indeed was void, was unenforceable. And in fact, there is an argument that they went so far, the Court of Appeal, as to say that a named driver's clause is no longer effective in the Bahamas. And I think that's the Section 12 point, which I'm told you don't need to hear me on, so I won't digress into that. But we say respectfully that was clearly wrong. Coming back to this specific point, we say that this policy, there's no conflict between the policy and the certificate. The respondents have contended in their case that there is a conflict. Respectfully, we say there is no conflict at all. There is complete harmony between the two documents. The policy directs the reader to the certificate to find out 2 critical facts under this policy. 1, who can drive this vehicle? And 2, what use the vehicle can be put to for the purposes of putting the policy on risk. The policy itself does not address either of those 2 points, other than to refer to the certificate. And I think that I've already shown you that when we looked at the policy a moment ago, and your lordships will see that again at page 104. Now, if I can take you back for a moment to the policy general instructions at page 108, I think this makes the point as best as I can. this is the section that deals with general exceptions. And first of all, we've indicated, Milads, I showed you on page 98 that the general exceptions apply to the entire contract. We looked at that point. Now, if we can look at general exceptions, your policy does not ensure the following, and it is really the third bullet point that is relevant. Any liability, injury, loss, or damage arising while any motor vehicle insured by this policy is being driven by or is in the care, custody, or control of anyone who is not an authorized driver. Now, there's a definition of authorized driver, Milads, on page 99. And you will see that this points directly to the certificate. Authorized driver, the right-hand column, the persons named on the certificate of insurance who are covered to drive under the policy. So it is difficult, we say respectfully, to see any conflict at all between the policy and the certificate. And indeed, the certificate is in a prescribed form, in perfect compliance with Form B in the regulation. And so, my lords, it is our submission that first of all, the policy does not give rise to any ambiguity. So the contra preferendum doctrine does not really arise at all in our respectful submission. There is no ambiguity. Indeed, there may be an attempt to find an ambiguity in the policy, but respectfully we say it does not exist. Secondly, we say that the policy and the certificate are completely consistent and in a standard form, and there's no conflict between those two documents. And thirdly, when construing Section 2, it has to be construed subject to Section 3. And when that exercise is carried out, we say, at the risk of almost sounding too simple, bearing in mind that we're before your lordships, we say respectfully.
We don't mind it simple.
Well, let's hope that I'm right. But we say the matter is fairly straightforward, my lords, with respect. We say that when you construe it, what this policy covers is CCT in respect of the insured vehicle when it is being driven by an authorized driver within the scope of the limitation of use set out in item 6 of the certificate. That's when the policy is on risk. We say that is compliant with Section 10 of the Road Traffic Act, which is our section that deals with compulsory third-party insurance. Your lordships will know that Section 8 makes it an offense to use a vehicle on a road without a minimum level of insurance as set out in the Act. Section 10 says what that insurance must be. In our submission, this policy is perfectly consistent with Section 10, and indeed,
well, there's no requirement under Section 8 to insure the whole world. Driving your car, you can, if you want, have a named insurance.
Indeed, Milad. I mean, in fact, that I think is what the authorities clearly establish. And minimum third-party insurance is not required to cover the whole world. And that's why I put it the way I did, Milad. This policy would have to comply with the minimum requirements of Section 10, and it did. It's not ambiguous. The certificate and the policy have to be read together. They are in perfect conformity, and Section 2 must be read in the context and subject to Section 3. And in that way, the puzzle is perfectly symmetrical. And there is no difficulty as to what happens here. What is the result? The result is that this insured, in its wisdom, elected, for whatever reason, to have a named driver or an authorized driver clause. That was its election. It had a perfect right to do it, and that is allowed under the law in the Bahamas.
Well, if we're just looking at rights, the Court of Appeal obviously felt quite strongly, and one understands the feeling, that this result is not a very satisfactory one, and it urged some legislative action or a fund on a voluntary basis, and one's conscious from other cases that this is a problem in the Caribbean as well as in the Bahamas. What is the... nothing has been done. I mean, you're not able to help us, presumably, as to why, but is there any thought being given to this even?
Well, my lord, it's a lamentable fact that the court, the panel, the board adverted to in presidential. The situation is exactly the same in the Bahamas. All I can say, and obviously at the bar I have to be careful not to give evidence, but it is a subject that has attracted public debate from time to time. But up to the present time, there has been no, and if I may put it this way, political will to actually implement an MIB in the Bahamas or something equivalent to it.
And the insurers themselves haven't thought of doing so?
Malad, not that I am aware of. I don't know whether they have ever spoken to the government about it. I know it's an issue that has come up. I represent a number of insurance companies. But the fact of the matter is, sometimes, and I have to be careful how I say this, sometimes we only seem to get statutory intervention when it's absolutely necessary. And so the priorities of the government seem to dictate what legislative agenda they have. And so the net result is that this has not reached the top of the legislative agenda as of this date. And so you end up with a situation where innocent victims do fall through the gaps. Respectfully, we say the answer is not judicial legislation, which is what I respectfully say the Court of Appeal did. Perhaps for noble reasons, but nevertheless we say respectfully in error. For instance, if I might just point out one, I won't belabor this point, but I just would make good on it by referring you to one paragraph. If I can find it quickly. Yes, it's paragraph 40, which I just think is illustrative of the error that the Court of Appeal fell into. It's on page 348, where the learned president said, moreover, section 14, and that's the section that deals with the prohibited exclusions. Moreover, section 14 lists particular exceptions, which if contained in a policy of insurance under the Act, cannot constitute grounds for avoiding liability under the policy. This means that any attempt by the parties to limit the insurer's liability through the use of those particular conditions and exceptions cannot avail the insurer. Now here's the remarkable sentence. These specific conditions and exceptions are not exhaustive and represent those which have arisen and have been accepted in practice. Well, with great respect, these are the exceptions which are in the statute. There's nothing to do with practice. They are exhaustive to the extent that there's nothing else in the statute that's prohibited.
Yeah. Well, this is an Aunt Sally, isn't it, Mr. Marie, because this isn't central to the Court of Appeal's reasoning.
That is so, Millard. I mean, one could certainly take that position. But it just seemed to me that with respect, that the court was understandably sympathetic to the victim because there's no MIB, and sought, understandably, with respect, to actually devise a solution which really went outside the statute. And we say respectfully it fell into error, albeit for very good reasons. but nevertheless dangerous, and we say not in a manner which was acceptable. But going back to the construction point, that's what I was asked to address. I have cases on it, Malaz, but I don't want to speak to the choir, so to speak. I mean, our submissions, and unless you wish me to take you further, our submissions really revolve around those points that I have made.
Yes. Yes.
It's all about Section 2 and Section 3.
Well, you've made them very, very clearly, Mr. Marie. I don't know whether my lords have any questions that they might like to ask you. I think Lord Toulson did have a question.
One question on your written case. You largely support the reasoning of a Chief Justice,
We do.
but with one exception. The Chief Justice, at paragraph 29 of his judgment, MS 164,
I have it, thank you, Malaz.
expressed the view that there could be no doubt that if the policyholder were a natural person, the policy would be in effect when that holder was driving. In other words, it would cover his personal liability for his own negligent driving, but he distinguished the vicarious liability of the policyholder when it's a limited liability company in paragraph 31. The Court of Appeal's approach was that, as we know, the liabilities, personal and vicarious, of the policyholder, be the policyholder a human being or a company, are on the proper construction of the policy covered by it. Alternatively, the exclusion clause is statutorily inoperative. The respondents say the Court of Appeal was right. You say that both the Chief Justice and the Court of Appeal were wrong, because it's your argument that in the hypothetical addressed by the judge at paragraph 29, he reached the wrong answer.
Yes, Malaz.
Now, I just wonder whether that is correct. You've taken us to the words of the policy. Can we just look back at them one moment? You pointed out the general exclusion applies to all parts of policy, and you rely on general exclusion 1, bullet point 3, driven by anyone who is not an authorized driver. That then throws you back to the definition of authorized driver. There were so many copies of the policy in the bundle, and I've actually been working off a different one than the one you quoted. So
It's on 99.
99 on this version. Thank you very much. The authorized drivers, the persons named on the certificate of insurance who are covered to drive. Now, one's familiar that in many contexts, a person may include a natural or a legal person. Chief Justice has taken the view that in this context, person means human person, because this is a policy about driving, and while a company can, as a legal entity, do many things, a company can't get behind the wheel of a car. It's an act of somebody else for which it may have a vicarious liability. It's not something it can do itself. Therefore, he reads person in this context as meaning a human person named on the certificate who are covered under the policy. If you then go to the certificate, if the policy holder were identified as John Smith, and then there is the additional category of persons in 5, would not John Smith be a person named on the certificate as someone covered by policy?
Covered to drive.
Well,
They wouldn't be named as someone covered to
well,
drive.
that's exactly my point.
They wouldn't.
It wouldn't be named in item 5.
Common practice
It's to
in this
policyholder
country is to put policyholder's spouse, and anybody authorised or the named drivers.
Indeed, my lord. My riposte to Lord Tolson was going to be, the usual procedure is to put the policyholder in item 5, together with anyone else who you would wish to be authorised to drive.
Because you can have situations, for example, where you own the car, but somebody else is the only person
Absolutely.
authorised to drive it. It
I
might
know-
even be your son or your wife.
Milan, I know this, one real example of that was a case recently I was involved in where an elderly grandmother bought a son for her grandson.
The car, yes.
I beg your pardon, a car for her grandson. She had no intention to drive the car at all. So she wouldn't necessarily be an authorized driver just because she is the policyholder, and she had to be the policyholder because she's the one who had the insurable interest in the vehicle. So I think my answer, Millard, would be that if the policyholder was John Brown, an individual, he would still have to be named in item 5 in order to be authorized to drive.
Yeah. Well, it's not a point which arises for direct decision, but it is, there is at least a rational basis, is there not, for giving the word person named the interpretation that it refers to a human being.
Millard, it could be, and frankly, I would have no difficulty with that, but I would still say that the individual would have to be named in item 5.
But the point I'm really driving at is that if the Chief Justice could be right or wrong on that point without it logically following that the company must be treated in the same way. Do you have any comment on that proposition?
That the company must be treated the same way as an individual would be?
Yeah, then in other words, it is whether the Chief Justice's reasoning on that point is or is not sound, i.e. in the view expressed in paragraph 29, is not critical for the determination of the issue before us.
Well, Millard, I certainly accept the latter point. Absolutely.
Right. Well, that's the point. Thank you very much.
We don't need to decide it, is what.
Well, just on that point, and with this subject to anything further from your lordships, I think I can conclude. But just on that point about the policy holder, if it is an individual, would have to be named in item 5. I do have 3 cases before you where that in fact occurred. I'll just very quickly point them out to your lordships. If we look at the Dobson case, that's in the bundle of authorities at tab 19. And specifically, it starts at page 760, but if I can take your lordships to page 763, just to make good on the point, which I think is fairly clear.
So we don't have to rely on our own number.
No, I hope I can give you something to rely on other than your own experience, but it's always good when it validates that. It's at the bottom of page 763 in the judgment of my Lord Mance.
Yes, well, it's the same. Yes, it's fine.
Really,
To look at cases where it has been done in a particular way
doesn't actually help us as to whether it has to be done in that.
I understand. I take your point, Millard. I was just doing it on the basis that it seems fairly usual for the policyholder to be named, but I would entirely accept my Lord's point. It's not dispositive of the point, so perhaps it's not helpful for me to do this.
Well, you would run straight into section 3, wouldn't you? I mean, if it was an individual and he came along and said, I was driving the car, I wasn't one of the named drivers, and I'm entitled to cover, then he'd be met by a general exception in section 3. Your policy doesn't insure the following: any liability, etc., insured arising while any motor vehicle insured by this policy is being driven by or is in the care, custody or control of anyone who's not an authorised driver. And then you have to indulge in some, go back to authorised driver, it's got to be someone who's covered to drive. You have to indulge in some quite extensive reinterpretation to treat that as referring to anything except point 5 on the certificate.
Indeed, Millard. And that is why, respectfully, we say
Actually, it's named on the certificate who
Yeah,
covers. But,
yeah.
you'd almost have to rewrite it in our respectful submission, but you certainly would have to be involved in some gymnastics in order to get there. And so, my lords, I conclude by respectfully submitting that the Learned Court of Appeal erred in deciding that the appellant, the insurance company of the Bahamas Ltd, is responsible to indemnify the insured by paying the judgment, the amount that's due under the judgment, in favor of the respondent, Mr. Antonio. That is the judgment, your lordships will recall, against Mr. Edgecombe, the driver, and CCT. We say that the Court of Appeal was wrong to hold that under Section 12 of the Road Traffic Act of the Bahamas, the appellant is liable to pay that amount of the judgment. And we would respectfully ask your lordships to set aside the decision of the Court of Appeal with costs. I'm obliged for this.
Thank you very much indeed, Mr. Marie. Ms. Sands, do you follow? Thank you. Mr. Parker.
Please, your Millard. Millard, the contract which my learned friend, the appellant, is seeking to construe is not the contract between the parties. We intend to show, Millard, that the Court of Appeal was correct in its construction of the contract. The first line of approach to construction has to be the words in the contract. If I may take your lordships to the principal indemnity under Section 2. If I am to adopt the method of construction employed by Taki LJ in the first MS 104 is where that first indemnity is to be found in the document.
Yes.
According to Taki LJ's method of construction, the first approach is to construe the words for what they actually mean without any reference to the facts of the case at first instance. When we do that, and I apologize for the crackling sound that's coming forward.
Don't worry.
It's usually not that way. What we find is the appellant contracted to insure CCT for all sums which it might have to pay for the death or bodily injury to human persons or their property which arise out of any accident involving any vehicle which your certificate of insurance allow you to drive or use. Now, that is a full indemnity. It makes clear what the appellant undertook to provide, with one variable and one condition only. The variable is the identification of the insured vehicle, and it refers the court, the reader, the police, any interested person to the certificate. Go there and look. You'll find the identification of the car. And the other part of that indemnity is you, because you is defined. Any vehicle which you are allowed to drive or use per the certificate of insurance is covered, and our liability is restricted to your use and driving of that particular vehicle. Throughout the appellant's thrust, use is de-emphasized. CCT could only use the vehicle and could only do so by means of the hands of its servants or agents. That is the only liability which it can insure. Its vicarious liability and its common law liability to see to it that its work or its buses were carefully or not negligently driven. That indemnity is the core indemnity which would bring the policy into compliance with Section 10. Without it, the policy doesn't comply. That is the indemnity which takes the owner out of or removes it from the penalty imposed by Section 8. Now, that is the principal indemnity which must be included, but there is an extension to the policy and the liability which the appellant undertook to insure. And the appellant seeks to treat the extension as the principal coverage. They turn the policy, at least they attempt to turn the policy on its head. They attempt to tell the court that the certificate of insurance is the primary document, but it isn't. It is a servient document. It doesn't govern the policy.
To whom is the extended cover given?
Sorry, my lord?
To whom is the extended cover being given?
To whom? Oh, it is to persons who have been designated.
But who are they?
They are persons who are or may be named at the discretion.
But are they people off the street? Are they friends or of the director of the company, or what?
The policy doesn't tell us, my lord.
No, but as a matter of common expectation, who would you expect them to be?
Well,
let's take two hypotheses. Let us suppose that they're the neighbours on the block, nothing to do with the company, right? If there's an accident, on your interpretation of the policy, Are the employees covered?
That depends, my lord.
No, are they covered or not? There must be a yes or no answer.
Well, I'll have to understand more clearly, my lord, the question.
Well, when you have a motor accident, two people are liable. Firstly, the driver, and secondly, if the person is driving in the course of the employment, the employer. Now, let us suppose that these named persons are people off the block who the managing director wants to, for some unknown reason, give cover to. Nothing to do with the company. So they're not driving in the course of their employment. All right, they've got cover if they happen to be driving on your analysis and the company is not involved. But let us suppose that the car is being driven by someone like the gentleman who was actually driving it, who was an employee, right? And the third-party victim brings a claim naming him as a defendant and naming the company. Now, on your analysis, the company is covered, but the employee, what's the position?
On our analysis, the employee is covered.
Hy? Where's he covered?
On this basis here, my lord.
He's not the company, and he's not the named driver, so he's not covered, is he?
If he is an employee driving in the course of his employment, under the clear words of the principal indemnity issued to the policyholder.
Under which words?
Under you, the policyholder.
Well, he's not the policyholder. The employee isn't the policyholder.
No, my lord. What I'm saying, he is. What I'm saying, my lord, is that your lordship's question was whether the employee who is not named on the certificate,
Right.
if he were driving
Yes.
in the course of his employment,
Yes.
would he be covered?
Yeah.
No, he wouldn't be
Well,
personally, but the law doesn't require that.
Well,
What?
it certainly does, doesn't it? Require someone who's using a vehicle on the road to be covered?
No. What I'm saying, my lord, about to say, my lord, is this. What the law requires is that his driving puts someone in a position to be responsible for his driving, whose cover, whose insurance covers his driving. The bus at the time would have been in the use of the policyholder.
But let us look. He will be liable in tort, won't he? On my example, the employee will be liable in tort. Firstly, under Section 8 of the Act, the employee will be in breach of the Act because it is not lawful for any person to use a motor vehicle on the road unless there is enforced in relation to the user of the vehicle by that person a policy. But anyway, leaving aside that point, secondly, he won't have cover for his personal liability.
The employee.
The employee.
But his master's insurance would cover him.
Why would it cover him? He's not the policyholder.
No, he isn't.
No. So, and he's not a named driver.
No, he isn't.
So he's not covered.
I am trying to make this point, my lord, if I may refer to the example given by Shawcross, for instance, that when a policy, where is that in the bundle so I can directly?
Tab 46, isn't it?
At page 189, but when a policy is issued to a limited company, it is necessarily an insurance of the driving of the insured vehicle by someone on behalf of the company.
Sorry, which tab are you on? Tab.
We're at page 1056.
Yes, thank you.
It's the last paragraph, isn't it, Mr. Parker?
Well, what about the sentences? It was argued in Such and Burns that this section of the Act was designed to secure that in respect of vehicles owned by a company, not only should the company be insured against liability which it might incur, but the persons driving with permission of the company should themselves be insured. But this contention was rejected by the Divisional Court in Ellis and Hines.
There's another example which I would wish to draw to your lordship's attention. It would be Lester Brothers Coal Merchants Company Limited versus Avon Insurance Company, 1942. Lester Brothers, tab 32. In that, and I would be directing your lordships to page 113 of that judgment, where Atkinson J. came to construe the words being driven by the insured, when the insured in fact was a limited company. And he also had to construe the words being driven with the general consent of the insured. The claimant put forward in that case that because the company was a limited company, driven by the insured must mean that the company had to drive the car, and that being impossible, that the case had to fall under being driven with the general consent of the insured, which two clauses are fairly identical to what we are faced with here. Any vehicle which your certificate of insurance allow you to drive or use, emphasizing use, and what comes under other people. We will also insure anyone you allow to drive your vehicle. Those are pretty much similar or identical words. What his lordship said in Lester Brothers was that...
Well, I mean, this case in Leicester is actually on a different type of policy, but or different worded policy, but the question was whether the particular driving fell within one of two exceptions.
Yes, my lord.
One exception was not covered at all if the driver doesn't have a license. The other is if you allow some third party to drive, you're not covered if you know he doesn't hold a license. And so the question was, into which category does an employee fall? And they held that the employee actually fell into the more stringent category, the first one. So the fact that he didn't hold a license invalidated the cover, meant there wasn't insurance cover.
But
that we don't, I mean, that doesn't...
No. The one point for which this case is being cited, my lord, is this fact that his lordship is saying when or if it is held that an insurance company cannot drive because he interpreted the meaning of the word drive to mean being driven by or on behalf of the insurance or the insured for the purposes of its business. So while the companies it is accepted cannot drive, to insure the company to drive or use means that you are insuring the company by its servant or agent to effectuate that use and driving. That is a personal cover to the company, which can only be manifested through its employees and human agents. Now, that is where the Court of Appeal and the Supreme Court agree.
Just to get clear what you're saying about Leicester, you're relying on the very bottom of the right-hand column of 931, internal page 113, and the left-hand column of 932, internal pagination 114, where Mr. Justice Atkinson says, well, consent. It's not a very apt thing to say that an employer consents to the employee driving. He's more likely to be instructing the employee to drive his car. And so with those dicta, you ask us to go over to 104, section 2, other people. We will also ensure anyone you allow to drive, and you say, don't you, Mr. Parker, allow and consent, much the same sort of thing. And so it's not very apt, the reference to anyone you allow to drive, not very apt to cover employees. So, according to you, they're covered under you, the policyholder. Is that roughly right?
Roughly, my lord, except that I would say they are covered because the employer is covered and they're driving for and on his behalf and for the purposes of his business. I'd put the emphasis on the employer, who is the policy holder.
Very well.
And that is the primary indemnity conferred by the appellant.
So, on your analysis, how would a company which wished to get the benefit of the reduced premium which arises from naming drivers have to do it in the light of the prescribed form of certificate and this form of policy, perhaps? How would it, could it be done?
My lord, I have to... My position would be, my lord, that really the case here doesn't affect that ability by the appellant. The appellant went through that process. The difficulty we have here is they made a particular contract which reads one way, and now they have come to the court to say, we need you to read it another way for our benefit, but it doesn't.
Just tell me how they should have worded it.
Oh, very simple, my lord. If they would wish, or had they wished, to restrict their liability to the policyholder or the policyholder's use and driving of the insured vehicle to the named drivers, all they had to do was, where they go, just as an example, any vehicle which your certificate of insurance allow you to drive or use, so long as it is by the hand, or such driving is by the hand of a driver whose name you have procured to be included on the certificate of insurance. They had to include that in the first and principal indemnity. What your lordships will find now is that there is no connection between the policyholder's right to use and drive the insured vehicle and the other people. The two clauses are mutually exclusive and subject only to the discretion of the policyholder. The language says, anyone you allow, the choice is yours. As long, and now they put it, as long as you ensure that those persons' names appear on the certificate. Then, of course, if I'm right, and I submit that that is a discretionary provision, if you choose to name anyone to drive the vehicle. By the wording, all you have to do is make sure we put the names on the certificate. But it does not say that you cannot, or may not, or shall not.
Is there any commercial reason why a commercial bus company should wish to insure on its bus insurance third parties who were not acting in the course of its business?
I do not want to sound facetious here, my lord. Under normal circumstances, there shouldn't be. But the point is, if I may be permitted to put it this way, my lord, it is up to the appellant to write the contract in a fashion so as not to leave the elements of doubt which drove us here, which have been filled in by the Court of Appeal in favor of the persons who should benefit from any weak drafting of the policy. They now, so sorry. Yeah, I'm gonna okay. They now, meaning the appellant, wish to make the certificate of insurance the principal insurance document. And, my lord, their submissions. At paragraph, in fact, at their grounds of appeal, really. At ground number 6 of the appellant's grounds of appeal, they stated most succinctly the point that I'm attempting to make, that they wish to elevate the certificate to the status of policy and the policy to a definition bundle. This is their grounds of appeal. It's M396. And I would refer your lordships to ground number 6, last sentence, the very last sentence.
396,
Yes, my lord. 398, oh, so sorry.
398.
On page 398, but it begins, paragraph 6 is on page 7 at the bottom, and the paragraph to which I'm referring your lordships is at 398 at the top. There, they write, the policyholder would only be covered by the policy if the policyholder was indicated in the list of named drivers in section 5 of the certificate.
Well, that is the argument that has been made.
But the point is, the policyholder is in fact covered not by virtue of the certificate, but by virtue of the contract itself. The certificate is not a contract of insurance. The contract is the policy.
Well, the policyholder is only covered under Section 2 in respect of any vehicle which your certificate of insurance allows you to drive.
Or use, yes.
So even Section 2 takes us straight to the certificate of insurance.
Well, the point there is, my lady, that it might take one to the certificate of insurance, but what it does, it brings one back, because if we read the actual documents, and if I were to take your ladyship to paragraph 91, I think it is, of my learned friend's submission, where would that be found? 91. They are adamant that the insurer, and the insured, last sentence again.
So where are we looking at?
This is the submissions of the appellant.
454.
0454 is the number.
Thank you.
So sorry, Mark. They emphasize the point there that the bargain struck binds us. The bargain is in the four corners of the document. And if I were to refer your lordships located it, and I would refer your lordships to the case of Biddle and Johnstone. Only to emphasize the point that I have made. That is what? Tab 7 of the bundle. And I need to find where I wanted it. It is authority for the point, my lord, that the certificate of insurance is not the contract. The contract is to be found in the policy. And when there is a conflict between, or if there is a conflict between the certificate and the policy, it is the policy which has to be looked at to determine what it provides.
Was this a case in which the policy...
The certificate disagreed with the policy.
No, I'm asking you a different question.
Oh, so sorry, madam.
In the policy with which we are concerned, expressly provides that the certificate of insurance is the most important component of this policy. So, on the face of it, it expressly makes the certificate of insurance part of the insurance policy, which may or may not be a distinction between this case and Biddle and Johnston.
But the point is in the exception, where was that? But it is an important...
This is in the introduction, MS page 98.
The quote her ladyship was giving me from the certificate, from the policy.
And the trouble in Biddle and Johnson was that actually they didn't have the complete policy. It was incomplete, and they had to work out what the terms of the contract were. And so actually they appear to assume that the certificate correctly represented them.
Yeah.
So it's not on the present point, is it?
No, not at all, my lord, except for this point. It made the general statement of law upon which we rely, that the certificate, if I am to read Justice Brown's statement at page 126, where he says, it is my opinion, a certificate of insurance, this is Biddle and Johnston, is not in itself, without more, a contract at all, and therefore cannot be the contract of insurance required by the Act. By virtue of section 2051, which is 10.4 of the Act, a policy of insurance is of no effect for the purposes of the Act unless and until the certificate has been delivered. But this does not in my view, affect the position that the contract of insurance is constituted by and contained in the policy, nor make the certificate of insurance a contract itself. And that position is also substantiated or supported in Freshwater versus, where's that to be found? Freshwater versus Western Australia Assurance Company Limited. I ticked it. You found it? It's in alphabetical order. Tab 23, bucks. facts were not on all fours with ours. The position there was, my lord, that a third party, I think I'm remembering this correctly, the policy required arbitration before action, and the claim was eventually rejected because the matter had to go back to be referred for arbitration. But, my lord, what Hanworth MR said was, I think the policy of insurance itself, this is at page 522 of the judgment, I think the policy of insurance itself.
So how far down the page?
Second full paragraph.
Oh, yes. Thank you.
Must be looked at to see what it purports to cover. A third party such as the plaintiff, if he wishes to rely upon the policy, he is bound by the terms and conditions therein written.
Yeah.
Now, the effort to exclude the driving of the employee Edgecombe was dealt with by her ladyship in the Court of Appeal by agreement with court below. The policyholder is covered to drive or use personally, can only be done in this fashion. And if you deny his servant or agent, or its servant or agent's ability to be driving for and on its behalf and for the purposes of its business, you are denying any meaning at all to the first indemnity clause.
Why? Why?
Because the first indemnity clause says, we insure you.
Yes, they're insured. They are insured in respect of liability they incur, is the argument against you, when the named drivers are driving.
But
and a company, assuming the named drivers are in fact employees, as they might or might not be in this case, a company will wish to have personal cover because it's the natural target.
But, my lord.
And also, it's its own vehicle. It will wish to be covered in respect to the damage to its bus.
But the point we are submitting, that we are wishing to make, my lord, is that the policy does not provide that.
No, but you said the policy would be valueless. I want to...
No. What we are saying is that to deny the CCT, the driving of the vehicle by its servant or agent, is not to give any meaning at all to the principal indemnity clause, which was...
It does.
Sorry, my lord?
The point I'm putting to you is that it's actually necessary to give them cover, firstly, for their vicarious liability in respect of their employee, assuming the driver is a named employee, an employee named on the policy, and secondly, to give them cover in respect of their vehicle, which has been damaged. Might be damaged without any driving, might be somebody might drive into it in the street, might be stolen. So the cover is, on the case put against you, perfectly effective, but in a different way to the way you're asking us to submit. So that's the issue. You can't say it's not, has no effect, though.
I might have used the word effect. What we are submitting is that if CCT is not permitted to use the van by means of its servants and agents, the words, we will insure you for any sums which you have to pay for death or bodily injury to other people.
But the argument against you is that that's exactly what is covered, and that the people named are going to be employees, and if they're not employees, then this company is mad in taking out this policy because it's failed to cover its employees or the most obvious situation in which it's likely to be exposed. That's the argument against you.
And I apprehend, my lord, that the difference between what I'm putting in the argument that is against us is that we are submitting that the policy which was enunciated by your lordship as an example just a moment ago is not the policy before the court. That is not provided before the court, that the policy holder can only use the bus by the named drivers. That is not included in the principal indemnity clause. And if that was intended to use reference to the numerous cases on the point, like Kennedy and Smith and English and Weston and Pratt and Aegon Insurance Company, if that is what they intended, then it should have been put forth in clear terms, which would have left no room for doubt. And we wouldn't be here. They didn't put it that way. What they did do was to, and I will now go to the exception clause, which activates the named driver proposition.
It might be said, Mr. Parker, that on your interpretation, the insurance company is at risk whoever the bus company may choose to employ as a bus driver, regardless, for example, of their age, how long they have held a license, whether they have previous convictions for driving offences, or what sort of accident they may have. And the insurer can't protect itself or consider any of these matters in assessing the premium, although they're plainly material to the risk that it's taking on. It might be said that that's commercially an unrealistic scenario, and that on the contrary, one would expect a proposal form for insurance of this kind to ask questions about precisely those sorts of matters. And all that would be completely pointless if the insurance had the effect that you argue for.
The point, though, my lord, if I may pose it in explanation, is that to avoid the scenario that your lordship has just put to me, the drafting was always in the hand of the insurer. We have come to say the present policy covers the insurer and hence its employee in the circumstances of this case. We are not dealing with, as my learned friend put it regarding the judge's judgment in the Court of Appeal, we're not seeking any judicial legislation, we're just seeking strict interpretation of the contract before us. If they have left themselves wide open to attack here, then the answer is simple. Go and rectify it. My lord, there is no connection, I am repeating myself, I believe, between other people and policyholder.
So you're really saying, Mr. Parker, they could have put into this policy, in the case of a corporate policy holder, there is no cover for employees driving in the course of their employment unless they are named under number 5.
Yes.
Is that right?
Yes, my lord. Words to that effect. They didn't. And they now want the court to write it for them to avoid a liability which the courts below, well, at least the Court of Appeal.
Court of Appeal, yes.
And we do too, my lord, feel that they are, my lady.
Well, Mr. Parker, perhaps in answer to my Lord's question, we ought to have a look at Section 3. We're moving on to Section 3.
I was.
Yeah.
My learned friend began by saying, and I must commend his being consistent, that has always been their position, that you can't read 2 without 3. Our position is, if 3 turns out to be totally untenable, then the policy has to be read without it. What does 3 provide? And by 3, I'm only referring to the exclusion clause. Your policy does not, 108, my lord, of the proceedings, bundle of proceedings, the record, sorry, 108. Your policy does not ensure the following: any liability, injury, loss, or damage arising while any motor vehicle which is insured by this policy is being driven by or is in the care, custody,
No,
or
yes, can we just go through each one?
I was going to do that after naming
Yes,
them.
fine, sorry.
Care, custody, and control of anyone who is not an authorized driver. I said earlier, they wish to turn the contract upside down. If the policy doesn't cover, and the first point to be noted now is how important it is that they are maintaining, the appellant is, that the absence of the policyholder's name from clause 5 is significant. If it is going to be significant for one purpose, it has to be significant for all. The policyholder is not a named driver, but if the vehicle is being driven by the policyholder, and judicially that means being driven for or on its behalf.
Does it? Has one ever, in a named driver clause,
Authorized driver.
well, you say you could put in a company as a person entitled to drive, do you?
They could. There was nothing preventing
Yes, I see.
the policyholder's name from being in clause number 5,
No.
because it would be axiomatic.
Well, there would have been nothing to prevent item 5, including all employees of the policyholder driving within the scope of their employment, for example. You could have done that.
There were any number of options which they did not take. Now,
Well, which CCT didn't take.
Yes. So what's the submission on this one?
the exception clause does violence to the rest of the policy. It will effectively cancel it because the policyholder can't drive or use, it can't have care or custody or control of the insured vehicle because the policyholder is not an authorized driver. And control is one of the principal incidents of management, or ownership rather.
But assuming these are the employees, then the company will be normally caring for, having custody or control of its buses through them, won't it?
But, my lord, I will emphasize the word that your lordship used first, assuming.
Yes. Well, we
That-
certainly can't assume the contrary.
The point is here, my lord, that they again left the contract open to assumption when the words constitute the terms by which they are bound.
It's not. It's a slightly odd situation because nobody seems to have adduced any evidence about the proposal form or the surrounding circumstances, as one would have normally hoped. But
Well-
we certainly, you can't say it's vague because there are facts about which we don't know, because in reality this contract ought to be construed in the light of the surrounding circumstances, and we ought to know the facts, but all we can do is make a surmise as to what is likely, if that's relevant at all or admissible. Maybe we simply have to...
I'm having trouble with his accent. I'm having trouble with his accent. Sorry, my lord?
Yeah, I don't think I want to go any further, but that's...
Yeah. So the point I was making, I was about to make, my lord, is that even when we move to the exception clause, in the Supreme Court, the Chief Justice simply applied it as if exception clauses are to be applied and not construed. Her Ladyship in the Court of Appeal didn't deal with it to any great extent because she dealt with the construction issue, which took it beyond, if she was right, took her decision beyond the effect of because she took the position, as your lordship would recall, that Edgecombe's driving was the use and driving of the insured, the policyholder. And he, or it, sorry, was covered to drive. And therefore, to say that Edgecombe was not covered was to deny any meaning at all to the principal indemnity clause. So it did not leave room for the exclusion clause.
Now, I'm sorry, my Lord Reed has corrected me. We do have the proposal form at 81, and if one looks at that, unfortunately, we don't have the whole of it, but it says at the bottom of page 81, under following details of all persons likely to drive, it says various drivers, see proposals attached. Now, I mean...
Then then just over the top of the next page, there are specific questions about driving,
Yes.
driving history and so forth.
Absolutely.
And it appears that information was provided about that.
And driver warranty, see a schedule of drivers. Now, I mean, coming back to my surmise, is it very likely that those are anyone except its drivers?
Sorry, Mark?
I said, is it very likely that those are anyone except its drivers?
I can't hear him.
These are the bus drivers, aren't they?
My lord, we're having a little difficulty hearing.
I'm sorry. I think that's leaning backwards.
Yeah, I keep having trouble understanding your questions, my lord. I'm sorry.
Think we-
Well, we're looking at the proposal form, which asks who's going to be likely to drive.
Which page is it?
This is at MS 81. And the answer is various drivers see proposals attached, and so we don't have those, I think.
No. And there is then
There's a list of questions directed to the individuals who are likely to be driving. So whether they're under the age of 25, how long they've held a full licence for, whether they've been charged with motoring offences, etc.
and their traffic records are attached.
I do note that question 12 includes including proposer. So if the proposer were John Smith, he's being asked in the proposal form to state who is likely to be driving, including himself. So it would follow that if he's going to be driving and wants to be in the cover for his own driving, he has to put it down, doesn't he?
Oh, were you looking at the same form? There? Over here. And what's the? I see that, my lad.
You see that, yes.
I see what's listed, but I didn't get the lead up to it. from your lordships.
Yeah, you may give me the same answer you did before, but one might wonder quite what the point is of asking these questions. If any person, any employee is going to be covered, whether he's been mentioned here or not.
If any employee is going to be covered,
But they're basically trying to say, does this circumscribe this process? The point is, this may be the proposal from the policy didn't reflect this.
my lord, I'm not sure I get it fully, but I will stand, my lord, on the wording of the policy.
Yes, I think we understand. Actually, you've made this point many, many times, haven't you now,
Yes,
Mr.
I will
Parker?
stand there.
You basically say the policy covers two classes, the policyholder and other people. The policyholder can only make sense to cover the policyholder if, in the case of a limited company, it covers their employees, or at least those who are employed to drive and driving in the course of their employment, and to give effect to the exclusion in Section 3 would deprive that element of the core coverage of the policy of effect. That's your argument, isn't it?
If this is applied as written, and the court shouldn't be called on to amend it.
Yep.
If this is applied as written, the
Yeah.
policy is vitiated.
Can I ask a question which I think you may have been intending to come back to or come to anyway? Just let's look at the rest of the exceptions. What about the first exception? Your policy doesn't ensure liability, etc., while a vehicle is being used for a purpose for which the motor vehicle is not insured. Do you say that your employees are, and you, sorry, not you, convenient, CCT is covered, subject to that condition or independent of it when its employees are driving and the primary cover applies?
I would imagine, my lord, and I'd submit accordingly, that it would apply when the bus is being used within by any employee of CCT.
So that one applies, you say?
Which one is that, my lord, now?
The first one, this exception applies, used for a purpose for which the vehicle is not insured, so that if an employee like Mr. Edgecombe was driving and he was using the vehicle for a purpose for which it was not insured, for social, domestic and pleasure purposes, I'm sorry.
Racing would be an example.
No, so for racing, yes, that's right, for racing, that exception would apply.
We have taken the position that user is not an issue here.
No, but
Well, this is true, but we need to know how you think the rest of the exceptions would apply, given your stance that the third bullet does not apply. I think that's the question.
exactly, thank you, put much better than that.
If it is outside the bounds of user, I would accept that it would apply.
So that one applies, and the next one applies. If Mr. Edgecombe was someone who CCT knew was disqualified from driving, that exception would apply.
I would imagine that would apply as well, if that's a condition.
So, and the last two, is that similar too? The last two exceptions, driven with the knowledge of the insured or authorised driver in an unsafe condition or transported overseas, those would apply as well.
But
No, would those apply as well?
the condition thing here,
Would those exceptions apply?
with this caveat, my lord, when you look, if I'm understanding, let me read it again, my lord. Unsafe or unworthy condition or in damaged condition. In our present circumstances, I would regard the fourth one, unworthy, and the rest of it. We are in a juxtaposition there because the exception clause, if it is to be applied, takes care and custody out of the hand of the policyholder. And that was another.
Clause 5 only speaks to drivers, it doesn't speak to use.
You say all these exceptions are okay and valid, apart from the third one, because it's inconsistent with you, the policyholder. Isn't that it, Mr. Barker?
The one just above,
Deprives it of effect.
driven by or in the care, custody, or control. Well, that is the one we hear on now. Basically, yes, my lord. But the point is, it would appear as if care of the vehicle from the terms of the policy is a precondition to liability. And in the very clause, we get the contra position, because the named driver or authorized driver provision is the third bullet point, which makes it impossible for the fourth to be held against the insured. What I'm submitting, my lord, is similar.
Sorry, the fourth one couldn't apply, are you saying?
Because by virtue of what is above and the way the certificate of title and the policy is being put forward by the appellant, the fourth would prevent, the third takes out.
Yes, I see. We've got that point, but
Yes.
my lord's right, is he, that all the others would apply except for the third.
Because of
Yes.
the way the exception clause is written. If your lordships would recall that, I think it was English and Western, where the word household was up in question. Do you mean a household of which he heads, or do you mean one of which he's a member simpliciter? The duty is not ours to bring ourselves within the exception. It is the duty of the appellant. They have got to show how against these words, your policy does not ensure the following: any liability, injury, loss, or damage arising while any motor vehicle insured by this policy is being driven by or is in the care, custody, or control of anyone who is not an authorized driver. Those are their words. And the burden for any deficiency or fault in that drafting has to be borne by them if we are to apply their words to the policy. In the exception clause there, their whole premise falls away. The general liability has to apply. Because this is impossible.
We've understood your argument, Mr. Parker. Is there anything more you think you can add to it?
My lady, there is a lot more. What I'd like to do is not bore you to death with going through them. If the court is breaking any time soon, I would go over and pick out the 1 or 2 points that I may come back and say, my lord.
No, we're not breaking at all.
No, oh boy,
Not until you've finished.
I see. You, you do.
But I will ask you.
You've got them collated because I'm catching hell with my voice. You've got them collated? All right. Is there one?
Is there anything that you would like to say about section 12?
I basically agree with her ladyship's position on section 12, but approach on the matter of section 12 is it only comes into play if we are correct.
Yes.
Oh, if you're correct, it automatically follows.
If we are incorrect, it doesn't.
But if you're
apply, because it
incorrect,
has nothing to operate on.
does it add anything?
So you would notice, my ladies.
You didn't say anything very much about it in your written case.
No, one paragraph, basically. Because if we prevail in the construction, then Section 12 is simple. If we fail, it has nothing to operate on. It is actually almost a single issue appeal.
Sorry, if you fail, it has nothing to add. I mean, Her Ladyship thought it, the President thought it did.
No. What I'm saying, my lord, is this. Madam President, I believe it is, asked whether I wish to mention Section 12. I said I dealt with it very truncatedly in one paragraph because we regard the appeal as turning on construction.
Yes.
If the court finds favor with the fact that we urge that the contract is in such a patchwork of contradictory provision.
Well, we've got that point, but I mean, I think in fairness, reading the case on which Her Ladyship below relied, Motor and General Insurance Company Limited against Pavey in 1994, you say that we should, if necessary, follow that. But I have to say that reading it, it seems to me at present, and you may wish to address this, that the Court of Appeal has misunderstood the case and failed to quote the relevant passages, which make quite clear that it's based on the proposition that liability was covered by the policy and the insurers were only entitled in the particular case to deny liability because of a breach occurring after the accident, and the breach consisted of failing to follow forward to the insurers the writ. And they make quite clear that they're confining what they say to breaches following the accident, and that if there had been no liability at all at the time of the accident, then it wouldn't be a liability insured. And that is the wording of Section 12 of the Act. It's a precondition to the application of Section 12 that the liability is a liability covered by the terms of the policy. So that Pavey is in fact against the proposition which the Court of Appeal relied on it for, rather than in favour of the proposition. That's the point I want to put to you, just so that you know where my current thinking is, and it may be wrong, but I can give you the references in Pavey.
My lord, I have read Pavey to the point where I was almost speaking with a Trinidadian accent. It was in my original draft. I took it out.
Yes,
I finalized.
I noticed you didn't refer to it, yes.
I didn't bother to put Pavey there. Our position on Section 12 is very simple. If we succeed on construction, Section 12 is axiomatic, it's automatic. If we fail on construction, in this case, it has nothing to operate on.
Right, that's what I thought you said, yes.
That's my position.
So you don't actually support the Court of Appeal's view on this?
I didn't think it was, if you would look at paragraph 27 of the Court of Appeal's judgment, find that for me. Her Ladyship dealt with her judgment, and I think it's important, at least for me to make this point on fourth behalf, in two sections. When she got to paragraph 27, she says, having concluded as I have, 342, MS 342.
Well, she's right that the further point, Section 12, is a point of great general public importance.
And
so we ought to deal with it, oughtn't we?
And she opened that analysis because the court below completely ignored it and didn't deal with it. But what she said, the Supreme Court didn't touch Section 12 from any analytical point of view. What she said prior to that is, she said, this would be sufficient to determine the appeal. So it was almost academic if I'm not using the wrong word there, what followed. And I didn't myself lay much emphasis on what followed because I apprehended bar to be on the construction side. But
It's not academic. I mean, it's positively explosive, isn't it? In terms of the structure of the understanding hitherto, it would mean that if you got any judgment against an insured, then whether or not the liability was covered by the policy, you can always look to the insurers, and that is. I mean, legislators can do what they like, but nobody hitherto has thought that Section 12 ever did that. Pavey was quite a generous interpretation of Section 12, but it doesn't go anywhere near that.
I was only taking the opportunity to explain to your lordships the way I approached it in preparing for my presence here today.
Mr. Parker, speaking for myself, I do applaud your realistic approach to this part of the case.
Yes.
No doubt you have noticed the decision of the board earlier this year in Presidential against Mohammed, in which an analogous section of the Trinidad Act came to be construed, and the Court of Appeal's analysis of Section 12 in the present case is quite inconsistent with the analysis of the analogous act in particularly paragraph 16 of Lord Hodges' judgment in the presidential case. And cutting things short, the Court of Appeal in the present case simply haven't given proper weight to the words in brackets, being a liability covered by the terms of the policy. So, as you have conceded, Section 12 sends one straight back to the construction of the policy and doesn't add anything.
No. And I would wish to defend her ladyship's position in 55, though, I believe the court may want to, paragraph 55.
Yes.
Rightly or wrongly, however her decision was, she came right back to where your lordship has just been. In the present case, the policy covers injury to third parties. The restrictions in questions purport to limit this liability to name authorized drivers, inasmuch as EDSCOM falls within the class of persons covered by the terms of the policy and is not in any way in breach of any of the terms which would entitle the insurer to avoid or evade liability. The insurer under Section 12 is liable. What she is saying, I've been through all that about Section 12, and for the record, we do not make any submissions on it. But she did eventually reach back and said, I am still satisfied that I was right at 27. And we are content to leave it there. And that's what we did in the 12th paragraph.
Well, thank you very much, Mr. Parker. That's very clear.
I believe that means sit down too. My learned friend may have.
Thank you.
When he will call her.
Mr. Parker, do you wish to follow?
Yes, my lords. With respect to the construction of the policy and the point that my lord Mance took my learned senior to, well, actually it was my lady, with respect to the importance of the certificate of insurance. I believe that when it's the second clause 2 under very important on 98, the certificate of insurance is the most important component of this policy. The law requires that you have a current one of these in your possession, and it speaks to the context in which that importance is relevant to the policyholder, i.e. you need this to evidence your cover, and you need it to submit to return to us should you decide to amend the nature of your cover. However, as my Lord Senior pointed out, when we look at what is at play in Section 2, under you, the policyholder, it says that we cover you for all sums, as we have read, which you may have to pay for death of or injury or to other people or damage to their property as a result of any accident involving any vehicle which your certificate of insurance allows you to drive or use. When we look at the certificate of insurance and we look at the issue of named drivers in the certificate, Section 5 of the certificate speaks to persons entitled to drive. It does not speak to user in and of itself. The policyholder's user of the vehicle is not restricted, and furthermore, the principal, the first item on the certificate of insurance is vehicle. And the coverage under Section 2 says, any vehicle which your policy, your certificate of insurance entitles you to drive or use. So you turn to the certificate, and number one, front and center, the vehicle is identified. The policyholder is named. Now, my learned, the counsel for the appellants have suggested that in order for CCT to have been covered, they ought to have been named in Section 5. We do not agree with that. Our position is that CCTV as policyholder is named on the certificate of insurance. Its user is to be covered by Section 2, and it had the option of naming additional persons. It chose to do so. Those persons are listed in Section 5. The problem that the appellant faces in this case is that, having found themselves in the position where both courts below determined that the vehicle was being used by CCT at the material time, CCT's user being covered by the policy, they sought to now come back and circumscribe that coverage with reference to the named driver clause. The named driver clause speaks to itself when you have persons other than the insured driving the vehicle or using the vehicle at the material time. Now, when we turn to the Section 3 exceptions, particularly it says the policy does not insure the following: any liability, injury, loss, or damage arising while any motor vehicle insured by this policy is being, and I go straight to the third bullet, driven or is in the care, custody, or control of anyone who is not an authorized driver. The reason why that is so, that militates against CCT's cover, which both courts recognize the user, is that that takes CCT as a user of the vehicle outside of the policy in all respects, because it's not named in Clause 5. And we would submit that that elevation of Clause 5 to primacy is something that is not spoken to in the context of the policy. The reality is, while the question of commercial viability or expansion of risk may be live for the appellant, that is not for this court to, we would say it's not for the appellant to come to court and say, actually, we've written a policy that exposes us to quite a bit of liability that we would rather not have at this time. We would much prefer if you read our contract to suggest that the user by the insured is circumscribed to the use by these people, when in fact it doesn't say that. So and as the authorities point out in our written submissions, the burden falls on them when they proffer these papers to be submitted or executed rather by the policyholder. And nothing that has been advocated by the appellant creates the type of insurance that they are describing. They're describing an insurance to this court that says CCTV is covered when the vehicle is being used by these people, and there's also coverage for these people. It seems when you create two classes, you acknowledge the existence of CCTV's cover, because then otherwise you're repeating yourself. You're saying CCTV's user is circumscribed in this manner when you can't find it in the terms of the policy. I'll leave it there.
Thank you very much indeed, Mr. Parker.
Thank you, Melissa.
Very clear. Yes. Oh, Mr. Marie, is there anything you wish to come back on?
Lady, just literally 2 or 3 points. I won't be more than 5 minutes. Of course, to say there is an ambiguity does not create one. And with regard to the two sections that are under review, Section 2 and Section 3, try as one may to find some ambiguity. We respectfully maintain that there is not any indication of an ambiguity at all. I shall just start where my learned friend ended, Section 2. You, the policy holder, that's page 104. It is important to note that this policy of and by itself does not even purport to address who is authorized to drive or who is authorized to use the vehicle. All it says is you have to look to the certificate. So there's no inconsistency there at all. With regard to the point that if, going over to section 3, if the general exception bullet point number 3 is valid, is enforceable, it would, I think, to use the words of my learned friend, do violence to the contract, to the bargain. I think the answer is precisely what my Lord Mann said in one of his interpositions. That isn't the result at all. If you applied bullet number 3, it would simply mean that the policyholder, CCT, is driving or using the vehicle through the authorized drivers, which are listed in the certificate. Now, as my Lady Hale indicated, there was a very easy solution if, indeed, CCT wanted to cover all of its employees. All it had to do was in item 5 in the certificate, put in a class as opposed to names. If your lordships look at the actual certificate at item 5, I'll remind you is page 91, it actually, the heading of the item is persons or classes of persons. So all you had to do was say, all employees and or agents of the policyholder driving, in the case of employees, in the course of their employment. Then that would have covered all the employees, and the policy would have been underwritten on that basis. Now, of course, it is highly questionable whether an insurance company would have actually covered that. It would depend. If you have 3,000 employees, this is not a viable option. If you have 10 employees, then perhaps, of course, it could be done. And as my Lord Reed indicated with regard to the proposal form, which we looked at during my learned friend's submissions, clearly the mind of the underwriter was addressing the antecedents of the drivers as a part of fixing the premium and assessing the risk. That's what the form shows. Now, it's quite impossible to do that. If you assume that and let's remind ourselves that if indeed the board is engaged in a construction exercise, we have to look at the intention of the parties. Could it realistically be suggested that in this instance, bearing in mind you've got 11 named individuals in item 5, that indeed the policyholder was intending to cover everybody who was either employed or who might be its agent? Because if that was the case, why put in the 11 names? What would be the utility of identifying 11 if you were intending to cover everybody? It would actually render this item 5 redundant, because the 11 would be assuming they're all employees.
Well, we don't know that, do we?
No, my lady. But I must say,
They could just have been friends and relations.
They could have been.
Wanted to allow to drive.
They could have been. I must concede that. Although, of course, as I believe it was suggested, that one doesn't suspend reality altogether here. I mean, they're hardly going to be strangers off the street. But they could be family.
They could be friends and relations.
Yes, my lady, I accept that. But nevertheless, even if one is an employee, it would be redundant on the interpretation of the other side, because all employees would be covered. And so there would be no utility at all in putting in any employees. Now, as I've said, the simple solution to this, of course, would have been to put in a class, to put in the employees driving in the course of the employment of the policyholder. And indeed, if that's what they were trying to achieve, there's nothing wrong with the policy. There's no ambiguity. There's no inconsistency. That could have been achieved by simply putting in item 5 the appropriate class. Second point, my lords. My learned friend did talk about the certificate. I just want to make it very clear. We, of course, are not submitting that the certificate of itself is a policy or contract, or it is preeminent to the policy. That is not our submission. Respectfully, we say that the certificate is a component of the policy, is a part of the policy. It is an extremely important part. And I just point out to your lordships, if we look at the bundle of authorities, page 517, and that's the regulations the road traffic regulations in the Bahamas. I beg your pardon, it's the Road Traffic Act in the Bahamas, 517, and I'm referring the board to section 10, subsection 4. It speaks to the importance of the certificate, not in the sense of being preeminent or replacing the policy, but in the context of its importance in the context of the contract. That section says, a policy shall be of no effect for the purposes of this act unless and until there is issued by the authorized issuer in favor of the person by whom the policy is effected a certificate. And then it says in either Form A or Form B. So indeed, it is the certificate which triggers the effectiveness of the policy under Section 10, subsection 4. And of course, the policy booklet I've indicated to your lordships clearly points out to the policyholder the critical importance of the certificate. My learned friend briefly, and I'll only mention this very quickly, my learned friend did refer to Biddle and Johnston, and I'd only like to point out to your lordships on page 619 of that decision, and it is the last 7 or 8 lines of the left-hand column, which my learned friend referred to. The sentence beginning, in my opinion, a certificate of insurance is not, and here are the words we would emphasize, in itself and without more a contract. Well, of course, that is an entirely trite proposition, which we readily accept. It is not of and by itself a contract, it is a vital part of the contract. And finally, my lords, the only other point I wish to make, going back to the policy for a moment, section 2, page 104, in the words which you've now had read to you at least several times, so I will not do it again, the first paragraph under you, the policy holder, I would just emphasize to your lordships that this provision does not say that the insurance company is covering persons who the policyholder allows to drive. That is not what it says. It says the insurance company is covering those persons who the certificate allows you to drive. And the certificate is extremely clear. It is in a standard prescribed form, and the insured chose to go with a named clause, a named driver's clause, and that is what the bargain was between the insurer and the insured. So there is no inconsistency. I think my friend referred to it as the primary indemnity, which he says cannot be juxtaposed to the exclusion clause in section 3, and particularly the third bullet point. Well, I've indicated that it can be reconciled extremely easily by simply saying that what does the certificate allow the insured to do here? It allowed the insured to use and drive the insured vehicle through the named drivers as provided for in the certificate of insurance. And we say, my lads, that's the solution to the so-called ambiguity. I'm obliged.
Yeah, just before you sit down, you want to say anything in response to Mr. Kallio Parker's point about the language of the exception, including care? I think the point that he was drawing to our attention, if I understood it right, was this. The exception takes out any policy coverage where the vehicle is in the care of anyone who's not an authorized driver. it takes out coverage against, among other things, any injury, loss or damage arising. The exclusion applies to the whole policy, including Section 1, which provides comprehensive cover. Therefore, it's said that, read literally, if there's damage to a bus when it's, say, on the forecourt of the premises, under the responsibility of whoever's in charge of the forecourt, or simply in the custody of the company itself, which isn't an authorised driver, then on its face there's no coverage, in which case the so-called comprehensive cover provided by Section 1 shrinks to cover only while it's actually in the care of 11 named drivers. That, I think, is what is said. Now, you may say, well, that's nothing to do with the present case. But he says that to avoid those provisions having an unintended destructive effect, you've got to give a narrower effect to the exception clause. Do you want to make any comment on that line of reasoning?
Well, Your Lordship did anticipate my first response. It probably isn't directly relevant to this case because we're referring to, of course, driving, and that is very clear. But I understand the point in a more general context. In the case of Mr. Edgecombe, that is a clear case of whether, when he was driving the vehicle at the time of the accident, the policy was on risk. But on the general point, our submission to that would be that the care, control, or care, custody, and control would have to be in one of the 11 authorized drivers.
Is that necessarily right? I mean, the language of General Exception 1 refers to liability, injury, loss, or damage arising while any motor vehicle insured by this policy is being, and then all the subclauses relate to circumstances when it's actually being used out of the premises, either driven, 3 of them are driven and 2 of them are used or transported. It clearly is aimed principally at Section 3, and it may be aimed exclusively at Section 3. I mean, I take fully my Lord's point that if it's sitting in the garage, one is going to find a way of ensuring that if a loss, theft, or damage arises under Section 1, it's covered without nice arguments about whether it's in the control of an authorised or care of an authorised driver. Maybe it's in the control of the managing director, or who knows. But
Or the night watchman.
or night watchman. Section 1 is not dealing with, at least not dealing expressly with liability, injury, loss, or damage arising while a vehicle is being used or driven. It's just dealing with loss, stolen, or damaged vehicles in the air. I just wonder whether, I mean, although it says it's a general exception, although it's subject to it applies to the whole contract, whether actually they were thinking of this situation when they drafted it.
Well, of course, I readily embrace my Lordship's my Lordship's point, but I would say this: while it may raise issues with regard to Section 1, it clearly applies without any difficulty to Section 2. And that is the section which is in play. I understand if your Lordships are construing it, you have to look at the entire contract. But with regard to Section 2, the point, respectfully, is a bad point, because it is in complete conformity with Section 2 without any difficulty at all.
Yes, you did begin your address to us this morning by emphasising that the general exceptions were general exceptions which applied to the entire policy.
Well, that is what it
It
says.
takes a certain backing off.
Well, all I was saying is that it creates greater difficulty with regard to Section 1. But of course, I can't in any way renege from that position, because your lordships will remember that I actually gave you the reference. That's what it says. It applies to the entire contract, so I understand that. In construing that bullet point with regard to Section 1, I can fully accept that it may require some coalescing.
That's a good word.
In order,
Coalescing, I think that's a wonderful word to use. Yes.
in order to resolve it as a general construction point. But if the narrow issue before the board is whether this bullet point applies to Section 2, of course you have my submission that is fairly clear, and there's no difficulty with that at all. Indeed,
It must apply to parts of Section 1 because Section 1 includes damage by young or inexperienced drivers deductible provision, and that's therefore, Section 1 is also covering.
I certainly don't want to be taken as conceding that it would not apply. I was only slightly fudging, to be honest, to say that it's more difficult, requires a little coalescing, and we'd have to look at it. I must say I was focusing principally on Section 2, but I understand the point in terms of construing it.
Yeah. No, maybe my point needs a bit of further thought.
We may not be considering the construction of the exceptions in relation to Section 1
Yes, very well.
because they don't arise, but you never know.
Very well, my lady. Well, with those submissions, I'm very grateful to the courtesy of the board, and I'm obliged for your attention.
Well, the board is very grateful to all the people who have addressed it, and also to those who've been involved in the preparation of the very full written arguments that we have received and the papers. We do not underestimate the importance and sensitivity of this case, and we will take time to consider what advice we will humbly tender to Her Majesty.
Obliged.
The board is now adjourned.